Hello, my name is John Fulweiler. I'm a maritime lawyer here in Newport, Rhode Island. I practice up and down the East and Gulf Coasts, and I'm licensed in a bunch of jurisdictions from Florida to New Jersey, New York, and Rhode Island, as well as Arkansas. And I'll tell you about that sometime. But today we're going to talk about the differences between maritime arbitration and maritime mediation and why so many folks that work in the maritime world confuse the two. So take a look. From the boardroom to the wheelhouse, there is confusion as to the differences between maritime arbitration and maritime mediation. And there shouldn't be, because it's pretty easy once you've listened to this video to understand the distinctions. With maritime arbitration, think of it as a private courthouse, a private lawsuit. It's typically something that's begun through a contract. You typically can't force somebody to arbitrate something. And when you arbitrate something, your claim will be resolved. That's it. Now, compare that to mediation, where with mediation, what it is basically a settlement conference. It's a chance for the parties to sit down and take a moment to see if they can avoid having to prosecute or defend a claim by finding some common ground. Now, with arbitration, which again is a creature that will determine your rights, typically, and that with arbitration you have maybe 1 to 3 arbitrators, and you'll have hearings, and you'll probably present some written submissions, and the arbitrators will then issue what's called an award, and making a determination as to the parties' rights. And that award can typically be pretty tough to appeal, but talk to your maritime lawyer about the intricacies of appealing an arbitration award. Now, with mediation, typically what you have is you have one mediator who is generally schooled in dispute resolution. You'll meet in a conference room. The other side will be there. You'll maybe present a few comments about your position. Maybe you'll take an hour. I had a mediation recently where I took about an hour to present our claim to the other side. They'll stand up, they'll do their presentation, and then the mediator, in my experience, typically breaks the parties apart. He speaks to each party individually, with the idea being trying to understand, is there some common ground, a middle point where he or she can bring the parties together and there can be a settlement. And as they say about any settlement, a good settlement is where all the parties aren't happy. So, and with the mediation, it may be that the parties don't reach a common point. They're just too far apart, and so it does not settle, and the claim continues. And that's really the distinction between a mediation and arbitration. A mediation is an opportunity to try to resolve things amicably, whereas with an arbitration, it's really like a private courthouse. It's just another venue by which to resolve your claim. So if you've listened to this video now, you are now more informed on this issue than 99.44% of those in the maritime world. So thanks for watching. Appreciate it.